themselves, would we then say that this bench has ruled that the judge must sit? So it's really an individual decision of the judge to reflect upon the facts that are before him, the relationship that is being alleged, because why it can't be litigation, and it should be in the interest of all the parties that the judge is not biased, such that when you make it litigious, what happens is one side will be claiming the other side must prove a point, which they are not really very materially cognizant of. And it's really just the judge who knows the actual facts of the issue. And so it really is upon the judge individually to look at themselves and ask themselves whether the facts that are being alleged constitute what would amount to a bias. And when we make it litigious like this, we actually violate the Constitution, for the reason that the conduct of a judge is not meant to be subject of any proceeding before a court. That is a matter that should be before JSC, that should be before other tribunals. And the Supreme Court has told us that in Bellevue, that the conduct of a judge, because that's what is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of a proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we've proved the case or not proved the case is neither here nor there as relates to this issue. I'd like to refer the court, I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167, United Mine Workers of America in 1945. And there the court, the Supreme Court, found that I think one of the parties was asking for the entire bench to recuse themselves. And I'll just take maybe one more minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that that decision cannot be made by the bench. A question of recusal should be directed at the judge, and it should be the judge to make the decision whether they themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India, Justice Madan also pointed out the same. And finally, I'd like to refer the court to the fact that this is a sensitive matter, but is also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is the aspect of necessity that this matter must be heard. And there's also room for appeal should any person feel they are aggrieved by decisions of this court or the judges herein. And so what I would say is that I would ask that the individual justices, that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.
My lords and my lady doctor, if it pleases you in the matter, my name is Wamboi, Shadrach Wamboi. I speak with the blessings of my senior, Mr. Danstan Omari and Samson Yaberi, on behalf of the 9th petitioner. My lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling to question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and a dance of the blind, to the extent that the petitioners or the applicants making an application such as the one that finds itself before you sometimes refrain from even saying the very grounds upon which they make the application, as you have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they will think the applicant is saying about their conduct or their integrity. So for that reason, my lady and my lords, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that will flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Dari Limited. And there is something that is important that we must highlight. In this application, the Supreme Court was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that had been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lady and my lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application in petition number E015 of 2024, annexure marked DMM2, which is a letter addressed to my colleague Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? My lady and my lords, that should mark the end of my submissions. I shall pave the floor for the remaining minutes to my seniors to also speak some wisdom to what is in issue. Thank you.
My lady and my lords, my name is Sam Nyaberi, for the 9th petitioner in the 2nd cohort. I stand in support of the motion for recusal, and I juxtapose it in this manner. Recusal applications are tantamount to the court being on trial. It's a charge sheet for the court that it then will determine the parameters that have been set and the grounds that have been adduced to find or make a finding whether they merit. And in so doing, the court will not be given an opportunity to make submissions as we are doing. It's the court that is going to now render a ruling. Then the big question that we ought to ask ourselves, whether then the court is going to rebut on the heavy submissions that have been made, because going into the second room of going to analyze what the petition is all about will mean that we as the petitioners will have faith in even opening the second chapter of the proceedings as they are going to happen. So therefore, my lord and my lady, the point we are making is, kindly, there is enough evidence that has been laid before you to make a determination that indeed it is not available for the court to open the second chapter of going into the determination of the petition. I rest my case there. The balance of my time, I invite Omari to finish up and conclude.
My lord and my lady, mine will be very, very brief. One, the court, in determining whether the DCJ has powers to constitute a bench, made a finding that the petitioner was found guilty of an offense of addressing the gallery. His lawyers, all of them, never addressed the court. The lawyers were not addressing you. It is the petitioner who was addressing you. You have already made a decision that the petitioner was addressing the gallery. Will he have confidence to appear before him? Ahmed Nasir Sr., when he was constantly spotted by the Supreme Court that he was attacking the courts, the court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the deputy president have audience before you when the main substantive motion comes before you? You have already made up your mind that his job is to address the public. The rationale for this matter, going live and my brothers and sisters saying it's a public interest matter, is because 55 million Kenyans are waiting to see the free learned judges appear impartial. It is our submission from our client Sharia Mtani that based on that you recuse yourself. I'll give a small analogy. When I went to pay dowry for a friend of mine, we were told that that place, those people were witches. So that religion, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we feared, my lord and my lady, that these guys might destroy us. The petitioner is scared of this page. That's my lord.
Are we through with all parties supporting the application? In that case, Professor, you can continue.
I thank you, my lord, and members of the bench. I will try to be brief. My colleagues and I, I think, would like to be truthful. First, we would like to begin by observing that today is the 10th day since this bench was constituted. It was constituted on the 14th of October. There were petition 522, petition 550, petition 569. Nobody Nobody ever complained at all until we came here on Monday. And even then, the complaint was an ambush. The petitioners appeared before my Lord Judge Ogola on the 16th of October. Orders were made in their favor. They were extremely happy. No complaint. The 3 judges of this bench were in the bench in 522 of 2024. No complaint. This complaint is a complaint founded on the fact that on the 18th, the Honorable the Attorney General, for the first time, also got orders. Now, that is when this bench became a bad bench. It was a very good bench for as long as it gave any order to the petitioners. It became a suspicious bench when it gave an order, only an order to expedite the hearing. The Attorney General had wanted many things. They were all declined. I will address you, my lords, on the understanding that we have 2 petitions. There's one petition I call the Kerugoya petition. And there is another petition I will call the Nairobi petition. It is our preliminary submission that yesterday's ruling of the 23rd substantially addresses the issues raised in the Kerugoya petition, and that those issues are now the res judicata. There is issue estoppel. There is issue estoppel, a doctrine of law that states a question that has been resolved by the court cannot be litigated afresh in the same proceedings. It is our second submission that the first limb of the Nairobi petition on recusal that speaks to how the case was handled between the 18th and the 22nd is also substantially settled by yesterday's ruling. And I think my learned friends, most of them, were able to confirm that. And they complained about that. So what issue is alive? The only issue that is alive is the issue of recusal, allegedly on the grounds that I'm so happy that my lady has been spared any further unwarranted attack as regarding her standing. So I will not make any reference to that. It has been considered that it was made recklessly without any factual basis. And I think that what an ethical advocate of the Honorable Court should do is to start by saying, I apologize to her leadership for these allegations that are contained in a document that bears my signature. But that is not for me to say. So let us proceed to the 2 other allegations. At one point, I was very surprised to hear a submission that said that my Lord Justice Ogola is close to his wife. How can that be? How can that possibly be a bad thing? But a further extension of that argument was equally spurious. A professional person is entitled to an independent professional existence. be it the husband, be it the wife, be it siblings, be it children, they have independent professional, and I am shocked that that can be a ground. Another ground now made is that the Honorable Justice Mrima is a friend of the Speaker of the House. The Speaker of the House was my student. I don't know whether I should recuse myself. My Lord, if I may say this with respect, I have been a law teacher for 38 years. I apologize that that's not very long. There are 3/4 of the lawyers under the age of 50, I have taught them. I don't know whether I should recuse myself each time I appear against, including the Honorable Tom Ojienda here, Senator. Could you confirm that?
I confirm that you're my teacher.
And Judge Morogaru, Senator, the Solicitor General, the Attorney General. This is the nature of our profession. This is the nature of our profession. The Speaker is a member of the legal profession. The Honorable Justice Mrima is a member of the legal profession. How else are we to do our work? Paul Kibugi Muite, Senior Counsel, a personal friend for many years. On the day I got married, he brought me a copper coffee dispenser. Am I never to do any case with him? Should I always tell people? I know Paul Muite from when I was there. He came to my wedding, he brought me a gift. It cannot possibly be. That is not how this profession works. Let me very quickly set this, what I believe, we believe, is the standard. The standard is set in the case of the most important of this all is the right case, which has been talked about. When will you ask for an accusal? And I agree with Dr. Kamino when he says that no lawyer, no advocate should ever make an application for accusal lightly. Indeed, an advocate approached by a client who is making personal attacks against a judge that are baseless must return the brief to the client. That is the honorable thing to do. Now, I have referred you to the right case, but the most important of this all is the objective test that is set in the Rawal case. In the Rawal case, which you are aware of, Rawal versus Judicial Service Commission, the court says there is no basis for a judge to out. On the contrary, decisions abound that judges must not recuse themselves on flimsy and baseless allegations. It is our submission that a claim that the friendship that may exist between a party and a judge because they went to the same school, because they went to the same university, because they come from the same county, that is baseless. It must be demonstrated. Like was said in the case of Kaplan and Stratton versus Z Engineering Construction Limited, if disqualifications issues were to be raised, say, because a judge and a member of the bar belong to the same Rotary Club or the same Lions Club or the same sports club, there would be no end to such approaches. There would be no end. In this case, it has not been demonstrated that there is any way in which the independence of any of the judges here can be said to have been compromised. Let me say something relating to the Dari case, because I was involved in that case, again with my very good friend, the Honorable P.K. Moite, on one side, and my friend Paul Nyamodi. They were on one side, I was on the other side. I think that's why Mr. Nyamodi has now come back to my side, because we were the successful party in that case. And as one of my learned juniors here on the opposite side has stated, you need to understand the context of the Dari case. Because at paragraph 24, the court states this: the appellant's applicants herein are seeking a stay order from this court in the most unusual, strange, and dare we say disingenuous strategy. What had they done, my learned friends? We had litigated for a very long time. Litigated in England in the High Court, litigated in England in the Court of Appeal, litigated in the High Court here, litigated in the Court of Appeal here, litigated in the Supreme Court, and their final card, they had made a complaint against the Supreme Court. And what they were asking the Supreme Court to do is stay proceedings as we go to prosecute the allegations we've made against you. And I think the Supreme Court threw the sink at them. And that is why the decision says what it says. Now, I want to wind up by saying that if this court were to accede to this application, it would throw into disarray a critical public interest litigation when the country is in the throes of a serious constitutional crisis. And that is why philosophers like Dr. Muthomi say that cities burn as philosophers are quibbling on whether we need a bucket or a pipe to put out the fire. We are in the throes of a grave constitutional crisis. The court that we have been given to resolve this issue cannot stop sitting on the basis of the most flimsy allegations of friendship between parties, because I don't know of a single representation here that is not related to another. If you opened this door, you will have created a precedent where all a lawyer needs to do, an advocate, all he needs to do is to make a connection. To make a connection. You go to the same church. You go to the same mosque. You used to work in the same chambers. You were trained by the same pupil master. Our connections will never see. Like they say about taught actions. There can never be an end to taught actions. And there can never be an end to the relationships we have in the legal profession. An applicant must demonstrate that because of that relationship, there is reason to believe, demonstrated by either past behavior, past judgment, past ruling, past conduct, that a judge will be biased in any way. But ultimately, as the authorities I have cited to you state, a judge has taken a judicial oath. A judge has a judicial oath. He answers to his conscience and to his oath. And finally, I will say, because I've had the great privilege to sit as an arbitrator in numerous matters, both locally and overseas, I have never found a standard that requires that if a person who has a historical connection with somebody, without demonstrating more than that, can be the basis of recusal. I will now hand over, before Madam Timekeeper asks me to my learned friend, Mr. Gould.
My lords and my ladies, for completeness of our record, we have filed grounds of opposition. We also have filed a list and bundle of authorities, all dated the 22nd of October 2024. My lords and my lady, permit me to start by saying that judges, just like any other judicial officer, have a duty to sit. They sit to determine disputes between parties who come before them. That is what makes us a country governed by the rule of law. In that duty, my lords and my lady, it is important that I will file this matter before this court, and before this court, in my hope one of them will give. And that if I run into headwinds in any particular direction, then I must, as of necessity, run away from that court. My lords and my lady, this is a position that has been adjudicated, the fact that the court has a duty to sit, all the way to our Supreme Court. We have in our list and bundle of authorities provided, cited one of the cases as being a case of Gladys Beausoleil versus Judicial Service Commission and a second party. At paragraph 5 of that decision, the court says that the doctrine of duty of a judge to sit, though not profound in Kenya's jurisdiction, then there's a spelling mistake. Every judge has a duty to sit in a matter which they should duly sit in. Recusal should not be used to cripple a judge from sitting or to hear a matter. That duty to sit was buttressed by the fact that every judge took an oath of office to serve impartially and protect, administer, and defend the Constitution. In yet another decision, Peter Mwangi Gishuru versus the Attorney General and the Salaries and Remuneration Commission, at paragraph 61 of that decision, the court says, the court has a duty to sit on matters presented before it for resolution and should only recuse itself where circumstances permit, but not where it will create an unconstitutional moment by refusing to hear a litigant's case because the opposite party apprehends bias. In what context then should we understand that jurisprudence? My lords and my lady, it must not be lost on us that when we are dealing with momentous topical issues of conversation in a country such as Kenya, like what we are dealing with, these matters evoke emotions. Just like in our election context, whenever a party loses, it is never so easy to accept the result of that loss. It is for that reason that sometimes people have all manner of aspersions cast against the court, against the independent, let's call it all other independent organs of the Constitution, because a decision has gone one way or the other, in instances not favorable to one party and favorable to another. we must appreciate that we are in an adversarial system where, as of necessity, a decision will be determined or will be made in favor of one party as against the other. That said, my lords and my lady, learned senior counsel Professor Githu Muigai has made reference to the fact that the matter that is before you, though dubbed as recusal, is a matter whose subject matter has been completely determined. There is issue estoppel, and that everything that has been presented before you today are issues that were contained in the ruling that your lordships issued yesterday. As a starting point, I would make reference, my lords and my lady, to the application that was filed yesterday by our opponents. The application seeking to have questioning the empanelment of this bench. If you look at paragraph Y, 2024, the petitioners were surprised by the turn of events wherein they were served with an order of this honorable bench stating that the first and sixth respondents' applications dated 18th October 2024 was coming up for inter partes hearing. Again, that was an issue that was before you. At paragraph 4, it talks about the subsequent reference of the matter by the Chief Justice to the Chief Justice on the 18th of October. That was an issue that was before you. Finally, he questions the unclear circumstances that led to the placement of the file of this bench on a Saturday before you without the express directions of the Chief Justice. Again, my lords and my ladies, that was a matter that was before you. In the application by Mr. Njiru Ndegwa, again, the same thing. First ground, that the petitioners have learned that this bench sat on a Saturday, the 19th of October 2024. That was an issue that was before you. Paragraph 2, it says that the petitioners were surprised by the sudden turn of events. Again, the same language used by the other application. In the other application, a matter that was before you. Paragraph 6, it says that the petitioners are apprehensive that this honorable court has clearly demonstrated that the case for the Attorney General is more important than our petition, yet they are raising similar issues. Again, that issue was before you, and it was determined. Paragraph 8. Let me stop first there. How then do we treat all those issues that were before you? And if we're, just so that then we understand that these matters were before you, when you delivered your ruling, which was shared with us this afternoon, from paragraph 73 all the way to paragraph 96, each and every of these issues were responded to. I mean, determinations were made. At paragraph 79, for instance, the court says, but backed by this sequence of events, we take great exception to the petitioner's conduct that when favorable to the petitioners, orders issued outside the normal working hours of a court raise no concern. However, when the same court acts in an instance where it has been properly moved by the other parties and likewise proceeds to deal with an application at hand in the same vein, the petitioners show their indignation. That was a finding that was made. At paragraph 96, you even go further to say that one of the senior counsels went further by intimating that an exercise akin to the radical surgery may be forthcoming, a statement which we perceive as a veiled attempt at intimidating, intimidation coming from senior counsel. My lords and my ladies, what is left that you're supposed to determine again? It is an attempt to have a second bite at that which has already sailed. If for one moment we were to look at this application by Mr. Ndegwa Njiru, he then introduces very strange allegations. Allegations which he has had to withdraw. Everybody saw his discomfort at making reference to those issues. But as we all observed, these issues around making allegations and running away from them are meant to cast aspersions and indirectly intimidate the court. Permit me to say, or to make reference to paragraph 8, where they say, for instance, that the petitioners have credible information that Honorable Justice Mrima is a close associate to the proposed Deputy President, Mr. Kithure Kindiki, and that the said judge failed, refused, and or neglected to disclose that fact. Really? Is that an issue that a party seeking the resolution of a matter that they brought under a certificate of urgency would want to raise to be a reason for a judge to disqualify himself? What is this association that we are talking about? What evidence have we tendered that there is anything that would be considered to be either untoward or that would make it inappropriate for the judge to sit in these proceedings? In fact, they go on to add, in a paragraph that they sought to, one of the paragraphs, paragraph 10, say that this close association between Honorable Justice Mrima and the proposed nominee for the position of Deputy President of the Republic of Kenya might have caused this court to convene and sit on a Saturday with a view of assisting one party in these proceedings. Is that not outrageous, to say the least? We go on to say, at paragraph 11, that the petitioners are in possession of credible information that Mr. Justice Ogolla, who is the presiding judge in these proceedings, is conflicted as his spouse is a member of the Kenya Water Board, having been appointed by the President of the Republic of Kenya, who has in haste nominated Mr. Kithure Kindiki as his principal assistant. Allow me to pause on that allegation for one moment. What evidence do they present? Absolutely none. Today, let me take one step back. Yesterday, when the court was rising, we did put them on notice that we would seek to cross-examine the deponents of the affidavits that contained these very unfortunate averments. To try and cure that, they've then introduced a gazette notice. In that gazette notice, my lords and my lady, they then seek to say, gazette notices speak for themselves. The gazette notice says, that is gazette notice number 7515, in the exercise of powers conferred by those provisions of the law, I appoint Rose Ombaki and Florence Auma Oluoch to be members of the Kenya Water Towers Agency Board for a period of 3 years with effect from 9th of June 2023. The appointments via gazette notice number this and this are thereby revoked. That gazette notice is signed by the Cabinet Secretary for Environment, Climate Change and Forestry, Soipan Tuya. At what point, my lords and my lady, at what point does it become that it is His Excellency the President who appointed I want to use the words. His spouse is a member of the Kenya Water Towers Board, having been appointed by the President of the Republic of Kenya. When we come with such outright lies, what are we trying to do to the court, to the individual members of the court, to the parties before these proceedings? Is it a case of saying that we will get out of that court by all means necessary, including by peddling lies? My lords and my lady, these are the grounds upon which you're being asked to recuse yourselves. I've also seen there was, just give me 1 second, there was an equally strange averment about Lady Justice Freda Mugambi. Paragraph 16. Okay, let me just get that. Get Thank you. That Lady Justice Mugambi is conflicted as such as she could. Wait a minute. No, it's not this one. But there is an averment to the effect that Lady Justice Frida Mugambi was a student. Okay. 16. Okay. Yes. That Lady Justice Mugambi is conflicted as such she could recuse herself as she was Mr. Kiduri Kindiki's LLM student at Moi University, a crucial issue that she failed, refused, and or failed to disclose to the parties at the inception of a trial. My lords and my lady, the qualifications of our judges are no secret because they're state officers. You only need to go to the website of a Judicial Service Commission and you find the truth. My lord, my lady, when we saw these very strange averments, we took the trouble to go to the website of a Judicial Service Commission and we established that Her Ladyship Justice Wilfrida Mugambi got her LLM from Birmingham University in the UK. How then do we want to bring these lies and feed them to the people of Kenya, feed them to the court, and expect that on account of such flimsy, concocted material, then the court should recuse itself? Again, is it a case of us saying, by all means necessary, we shall not appear before that court? My lords, my ladies, there are clear standards and thresholds that have been established both by the regulations governing the conduct of a court and even case law. That, my lords and my lady, first, you exercise your conscience as to what should make you recuse yourself. Number two, in the event that a party is raising a concern as to your recusal, then it must be a substantial issue. It must be a substantial question that has been brought before you. It cannot be that every frivolous allegation that is brought before the court should make the court down its tools. That, my lords and my lady, will amount or will create or facilitate an environment where forum shopping will be rife. We'll just need to mention anything, that I went to school with so-and-so, that I'll go to church with so-and-so, that I traveled with so-and-so, and that should be a reason for them to recuse themselves. That certainly cannot be the standard. My lords and my lady, I would refer you to one of the decisions in our bundle and list of authorities. That's UNAD, Ex parte CJL 1986, 60 AL JR 528, where the court had this to say, that although it is important that justice must be seen to be done, it is equally important that judicial officers discharge their duty and do not, by acceding too readily to suggestions and appearances of bias, encourage parties to believe that by seeking the disqualification of a judge, they will have their case tried by someone thought to be more likely to decide the case in their favor. My lords, my lady, the question that we'll be asking ourselves is, what is that fundamental question that has been presented? And why this is an important concern is because sometimes such frivolous grounds are raised purely to embarrass the court. On this occasion, I have absolutely no doubt in my mind that the net effect of what these allegations have done is an attempt at embarrassing the court. My lords and my lady, we urge that you resist that invite. You resist that temptation to ask the court to recuse itself on the basis of such flimsy, baseless allegations. Just to further speak to the fact that this is an attempt at embarrassing, if not intimidating, the court. Our friends for the applicant have also indicated that they have simultaneously sent or lodged a complaint with the Judicial Service Commission. Following from the submissions that I made reference to in the ruling about intimidating the court with radical surgery, Again, going to the question of presenting this application for recusal after the one yesterday, and now going to lodge a complaint to the Judicial Service Commission, is that not an attempt at intimidating the court? My lords and my lady, I would not ask for an answer. That is an issue that anybody, any reasonable person out there would be able to make an indication or a determination about in their own space. My lords and my lady, is it also possible that this could be one of those issues that the applicants, or rather the respondents, have complained of as being a delaying tactic? Because we raised concerns yesterday. We are raising them again today. We have spent a whole afternoon arguing about issues that on the one hand had been completely determined by this court. The second part of those issues are issues that did not have any grounding, any material or in support whatsoever. Are those not meant to delay these proceedings by any means necessary? Having taken cognizance of the fact that we came to you, both parties, under certificate of urgency, these matters must be treated with the urgency with which we came. And so we ask, my lords and my lady, that you dismiss that application with the contempt it deserves. May I now invite my learned friend, Mr. Nyamodi, to speak to a few of the remaining issues.
My lord. My lords, my lady, I wish to commence my submissions in opposition to the application for recusal before you this evening by tendering an unreserved apology on behalf of the members of the bar who have been urging and opposing the application before you today. Despite my relatively few years at the bar, I appreciate that prosecuting an application for recusal, and I have some experience in prosecuting applications for recusal, and it will become apparent in a moment, are not easy applications to prosecute. But the reason that I offer the unreserved apology is that it is my humble and respectful position that however difficult they are, there is no need for them to be prosecuted in as bad-natured a manner as these applications have been prosecuted before you. And for that, I am sorry. The only mistake that your lordships and my lady have made is to serve your nation as judges of the High Court and choose to sit in this matter. We have been told that there is no difference between this matter and any other matter, and I affirm that there is no difference. It is a matter just like any other matter. I wish to start by perhaps completing a submission that was made and not completed by my learned colleague, Mr. Gumbo, who submitted a few moments before. The issue of your recusal was not just an issue in the grounds, in the notice of motion that you determined yesterday, but it was contained in prayer 5 in that notice of motion. And I do not understand why the petitioners complain of bias or any improper treatment by this court. Because again, in my few years at the bar, in my relatively few years at the bar, seldom have I come across an application dated today, had on the same day, and a substantive ruling running to in excess of 40 pages delivered the next day. So that issue has been dealt with conclusively by the court in yesterday's ruling. I wish to then focus on the authority that was cited in the dairy matter. And again, in my relatively few years at the bar, I have had the privilege of arguing several matters in the Supreme Court. Many of them are precedent setting. Dairy is one of them, and I did not know dairy would be one of them. But The ruling of the Supreme Court delivered in the dairy matter on the 11th of October this year has confounded me for a few reasons. I am still trying to understand what the meaning of that decision is. And I will share with your lordships some of my, some of the issues I have with that decision, and hopefully in your ruling you will help me understand them. The decision in dairy is not available as an authority for what the petitioners cite it to be. And one of the issues that confound me with that dairy decision, and if my lords, my lady, when you retire to consider your ruling in this matter, you take a moment and find the original script or the original version, not the one reported in KLR, but the one that is on the Supreme Court's website and was circulated to us on the 11th of this month. You will find that at the beginning of that ruling, Paul Nyamodi, yours truly, is referred to as senior counsel. Now, I cannot insist that I'm senior counsel because the Supreme Court referred to me as senior counsel in that ruling. That is the first issue that confounded me with that ruling. The second issue is that there was no application for the learned judges of the Supreme Court to recuse themselves. There being no application for the learned judges of the Supreme Court to recuse themselves, learned judges of the Supreme Court did not then have the benefit of argument from counsel for either of the parties as to whether or not they should recuse themselves or not. And if you look at that dairy decision, you will not find anywhere.
Perhaps you are disparaging the Supreme Court.
I am not. I am speaking about their decision. If you look at that decision, in the disposition at the end of that decision, the Supreme Court does not declare that it has recused itself. So if you were to extract the order, the issue of recusal would be absent. So in respect of that, I wish to submit that the issue of recusal in the dairy matter is then obiter. Having not been an issue before court, and having not been an issue that parties submitted to, it then cannot become an authority. It cannot then be cited as an authority for recusal. The second issue about the dairy decision, and the second reason why I say that dairy is distinguishable, is as follows. Unlike in this matter, where the issues, where the facts upon which the application for recusal are based have been judicially considered and a decision given, and that decision is contained between paragraph 74 and paragraph 96 in the decision you delivered in this matter yesterday. In dairy, the issues that the Supreme Court then suo moto relied on to recuse themselves had not received any judicial consideration. Yes, those facts went on to become a complaint before the Judicial Service Commission. In the same way, the facts that form the basis of your determination between paragraph 74 and 94 of your decision have gone on to the Judicial Service Commission as a complaint. But those facts now forming your decision, the proper thing to do is not to complain to the JSC, but to appeal. That is the proper thing to do. So to then file a complaint before the JSC and then reach for dairy out of context is wrong. And for those reasons, that dairy decision is distinguishable. And I urge you to distinguish it. The second decision that I wish to urge you to distinguish is the decision that was cited by my good and learned friend, Mr. Tom Macharia, the Navin Premji Kerry versus Virunga Limited decision. And the reason I want to urge you to distinguish that decision is as follows. A true reading of paragraph 5 and paragraph 6 of that decision show that the arbitration commenced on the 31st of March 2021. The traditional wedding which the judge then took offense to took place on the 18th of February 2022. So it is clear, and that is clear from a reasonable process of deduction, that the traditional wedding then took place during the currency of the arbitration. That is not the case here. The screen grab that has been produced of Mr. Justice Mrima and the Speaker of the Senate, if we are to believe that it is true, is dated the 9th of October 2021, more than 3 years ago. So this decision is distinguishable on the facts. Judges do not live in glorious isolation. Your appointment as a judge does not mean that you cannot invite your friends to a wedding. On the 9th of October 2021, Mr. Justice Mrima did not know that he would have to go through the torment of sitting on this bench. In respect of the Manchester Outfitters decision, I also submit that that decision is distinguishable for the following reason. Mr. Justice Laka had been an advocate for one of the parties. Again, in an advocate-client relationship, the client pays the advocate fees. And that relationship is not at play here. And for those reasons, I urge you to distinguish that decision. My Lord, there are two pieces or two annexures that we wish to make a specific submission on, and that annexure is the screen grab from Amason Kingi's account and the prophecy by learned senior counsel Ahmed Nasir as to what would take or what is going to happen in this matter. My Lord, those are electronic evidence. And those are electronic evidence I submit within the meaning of Section 106B of the Evidence Act. In the absence of a certificate required by Section 106B of the Evidence Act, that evidence is not admissible. My Lords, it has been submitted by those who have submitted before me in opposition of the application that the petitioners are guilty of forum shopping. I wish to persuade you also on my feet this evening that this application is a further attempt at forum shopping. My Lords, my Lady, you will not, because you are seized with petition number 522 of 2024, that on the eve of the impeachment hearing, the petitioners insisted at an hour not too different from this that you hear their application for conservatory orders. The application was heard, and you, with exceptional dispatch, delivered the ruling the next morning at 8:30 in the morning. My Lords, my Ladies, after the ruling, the learned counsel who are in court for the petitioners engaged you in a lengthy submission, which appears to be their stock in trade, on a request for leave to amend that petition. And the requirement or the request that they wanted, or the reason why they wanted leave, was they envisaged that perhaps after the impeachment proceedings in the Senate, there may have been need to have recourse to court and seek certain orders. But what did the petitioner do? The petitioner, and we are told that he was unwell, as he was unwell, issued instructions for this petition to be filed, for petition 565 to be filed, and conveniently this petition did not come to this bench. This petition went before another court, and surprise, surprise, before that court they got their orders. And it is those orders that they seek to defend here today. A request for you to recuse yourself is in furtherance of their attempt to forum shop. And my Lords, my Ladies, as I take my seat, I urge you to bear in mind the finding that you have already made about these petitioners. Paragraph 98 of your decision and paragraph 99 of your decision rendered this morning, or rendered yesterday, which with your permission, I ask to read. counsel also insinuated that this bench is part of a conspiracy to violate the petitioner's rights to a fair hearing under Article 50 of the Constitution. These submissions are without foundation and wholly without merit. The court has not issued any rulings or directions that would suggest such an intent. It is apparent that this argument was made for the gallery, and we find it unnecessary to address it further. This is in furtherance of that disposition of the petitioners. This is a serious matter. As has been submitted by my learned colleagues, you have a duty to sit, and we urge you to sit and dispense justice in this matter. I'm most obliged.
My lady and my lords, hot on the heels of submissions by Mr. Nyamodi, now senior counsel, I wish to state as follows. My lady and my lords, the serpentine and sinuous submissions by Ndegwa and by my learned friend, senior counsel John Aminwa, just in case he says I was breastfeeding, must be faulted for two reasons, my lord. My lord, one, Mr. Aminwa refers to the Richard Nixon impeachment as the first impeachment, when it is clear, my lord, that in the US, the first impeachment was that of President Andrew Johnson in 1868, coming after he dismissed a war general, Mr. Stanton. The Richard Nixon impeachment was the second impeachment coming in 1974, because you said that was the first impeachment, and Nixon resigned. It's just important for context, my lord. Yes, my lord, it's just important for context that in the second impeachment of Richard Nixon, he resigned on the 8th of August, 1974, and thereafter, the next president, Ford, took over for the next 3 years. I think it is instructing, my lord, to refer to this impeachment because of the case of...
Nixon was never impeached.
He resigned, I've said he resigned. After the Watergate scandal, the impeachment commenced and he resigned. And that is what gentlemen do when an impeachment is imminent. My lord, I want to connect this to my submissions, that we shall be relying on the political question doctrine and the finality of impeachments by Senate in a comparative context. My lord, let me submit that in Gladys Bolsholay versus JSC, this court set out a threshold for recusal. And the threshold is, my lords, that a recusal application must be made in good faith. And if the court listened to the histrionics from the petitioners, the courts will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scuttling the bench and scaring them away from sitting so that they can have open-ended and irregular orders issued in Kerugoya by... Then they went to the second act of actually filing a complaint with the Judicial Service Commission, submitted to Isaac Wamasa and duly acknowledged, so that this court can be scared away and run away. My lord, then the scheme is not complete. My lord, Judge Ibrahim, at page 31 of the Gladys Bolsholay decision, stated, my lord, that the threshold for impeachments cannot, for recusal cannot be so low, and every allegation made of any form of bias must be proved through credible evidence. My lord, I go I dive straight to Section 11 of the Oaths and Statutory Declarations Act. The petitioner's affidavit. The petitioner made a false affidavit through a deponent who swore to factual issues that the petitioner then attempted to withdraw in court. My Lord, that not only invites a criminal sanction under Section 11, but what is more important, my Lord, is that false affidavits are no affidavits and must be struck off. Because the penultimate paragraph in an affidavit, my Lord, swears to the truthfulness of the whole document. Where therefore, my Lords, any part of that document is false, the affidavit must be struck off. My Lord, we further submit that to both applications, my Lord, that are before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my Lords, that we have cited relevant authority. We have cited the authority in Jackson, Molalu, and others, a Court of Appeal decision on the threshold that learned friend Senior Counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. My Lord, if that were the case, no judicial proceeding would be conducted in this country. And learned friend, Senior Counsel Professor Gideon, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my Lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would accuse themselves, my Lord. No judge, my Lord, would sit on any bench to hear any case, because we are all extracted from the same academic background and a dual trend. Unless my learned friends are saying that. Oh, yes, my Lord, in response to the suggestion that the Honorable Justice Lima attended a wedding of the Speaker of the Senate, my Lord, the Speaker attended the wedding of the Honorable Justice. My Lord, the Honorable Justice Kingi, Amason Kingi, is a peripheral party in the proceedings. Indeed, if you look at the proceedings, my Lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker as a corporate office who is a defendant or a respondent in these matters. But number two, my Lords, the Honorable Speaker Kingi merely presided over the proceedings in Senate and was not a voting member in the sitting of Senate that led to the impeachment of the former Deputy President. My Lord, the Honorable Kingi has not taken part in the appointment of this bench in any form. But clearly, the petitioners are clutching on straws, and any attempt at ensuring that this court does not proceed seems to be falling by the wayside. I urge the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray, my Lord. My Lord, on the appointments of judges, my Lord, My Lord, clearly, if peradventure the argument on conflict extended to who appoints, my Lord, the President appoints all judges, and is a party. I think they should have added that ground, perhaps, because the President appoints all judges. But that cannot be a cause for a party seeking a recusal, my Lord, because the President, in performing a constitutional mandate, just like, my Lord, the CS Environment Soipanti exercised has title mandate in appointing Florence as a board member, my Lord, cannot be a cause or a basis for seeking or asking for my Lord, soon parties will then apply for recusal on the basis, my Lord, that two judges or a litigant and a judge belong to the same community. Thank you, my Lord.
Sorry, none of them is quite near me, so I think I will. Thank you. Thank you very much. Just a brief rejoinder to the application, and especially in view of what has actually been disclosed after the arguments. And my lady and my lords, I would be urging you kindly to actually go through these voluminous decisions we have given to you, because part of what some parties are submitting and they're saying it falls on all fours in relation to the matter before you is nothing far from the truth. And the example that has been cited is that of Erai and Virunga Limited, where it has actually been shown that that authority cited does not in any way relate to what is before you in terms of facts and the applicable law. It has been clearly demonstrated that here disclosure was necessary because...
Just a minute. We wish to adjourn for 10 minutes. You can take a health break for 10 minutes.
Will you say something? Yeah, we'll say something. You want to do that? No, I should do that. And you say it's political. It's political. Political. Public interest. This one is meant to derail. How long have you